The main discussion for the reading for today, of course, are these questions about the exceptions to the judicial review provision of the federal APA. Section 701, which lays out the exceptions, is the main focus, of course, and it talks about the idea that the chapter applies except to the extent that statutes preclude judicial review or agency action is committed to agency discretion by law. So the main topics for today's discussion are, number one, the issue of what counts as a statute precluding judicial review, and that's the decision in Bowen. And then number two was the question of whether or not an agency action is committed to agency discretion by law, as Heckler versus Cheney. And then there's this final discussion of the Utah Wilderness Alliance case, which talks about how you deal with a situation where the agency just hasn't acted, and what you need to do in order to try and maintain some sort of litigation posture there that the courts are at least going to be willing to listen to. So with respect to Bowen, the issue here, as the casebook discusses, the case is at 620, is the fact that the Department of Health and Human Services adopted a regulation under Part B of Medicare that basically provided for lower payments to, as the casebook describes them, allopathic family physicians than it provides to other generally board-certified physicians. Same procedures might be done by both sets of doctors. It was just that one type of doctor was going to get paid less than the other type of doctor. Now, the decision starts out with this presumption that we've talked about already, this presumption that there is an ability for judicial review. And if an agency acts, the assumption is that the APA is going to provide a mechanism for reviewing that decision by the agency. The only place that you don't get to do that is if there is persuasive reason to believe that Congress intended to cut off judicial review in a particular case. And this is described as being a situation where there is a heavy burden against the presumption that Congress cut things off. In order to demonstrate that there's an intent to cut off judicial review, the statute must upon its face give clear and convincing evidence of an intent to withhold it. Now, the trick here, of course, is that if it's explicit, if it says you may not review these decisions by an agency, that's easy enough, right? The trickier part here is that sometimes you can imply a decision by Congress to not allow judicial review in particular cases. And this is one of the examples of a situation where you see an argument being made that there's an implicit intent to preclude review. So as I mentioned, in this situation, you've got Part B of Medicare providing that certain payers, or certain providers, rather, are going to be paid less. These providers are going to be paid less, and there are provisions for judicial review of certain types of decisions under the Medicare Act. The Medicare Act says, okay, you can challenge through judicial review decisions that are adverse eligibility determinations, if they say you are or are not eligible to get reimbursed. That's something you always get judicial review for. There are also provisions that allow judicial review of amount determinations, but only in Part A of Medicare, not under Part B. Part B of Medicare says you get judicial, or you get, excuse me, you get to review amount determinations, but only through a fair hearing provided by the carrier, not by the agency, but by the carrier. And that decision is not subject to judicial review. So you've got two different approaches, right? Sort of everything, if it's Part A, can be reviewed. If it's Part A and you want to challenge eligibility, or if it's Part B and you want to challenge eligibility, that's fine. If it's Part B and you want to challenge amount, though, then you have to go to the private carrier, and that's all you get to do. So the argument here is that this type of challenge that's being made by the allopathic family physicians is something that fits within the scope of the Part B. You don't get to review it because it's a challenge as to the amount. So the court says, okay, well, we understand the argument, and we see, that this is a situation where Congress seemed to be specific about what gets to be reviewed and what doesn't get to be reviewed. And it's certainly possible to imply that there's an intent to exclude judicial review by leaving a chunk of review out of the statutory scheme. Here, however, the court says, you know, we don't think that that's what's going on, because we believe that what we're looking at here is a situation where Congress has said we want to allow challenges of amounts to occur, but only to happen in the context of the private carrier, because there's going to be thousands of these things. We're going to see them all over the place, right? This is, you know, the line at the top of 622 about there's going to be carrier review for millions of trivial claims, right? Those are the sorts of things that we don't want judicial review of. What's a little bit trickier, the court says, is what's going on here, which is this is a challenge about the method by which those amounts are set. This isn't just a, like, one time, you know, did you conduct that procedure or not? Or how much did that procedure actually cost you as a doctor versus how much didn't it cost you? Okay, this is not this kind of a trivial determination. The court said this is a challenge mounted against the method by which such amounts are to be determined, rather than a challenge to the determinations themselves. And the Secretary of the Social Security Administration says, you know, this is the kind of challenge that we wouldn't allow to occur in front of the carriers. So if you want to challenge the method of whether or not there is going to be this kind of a sort of initial setting of different levels for reimbursement, you know, you're basically out of luck. And the Secretary further points to this Section 395II that's discussed at the bottom of 621, which seems to say that federal court action against Social Security that isn't otherwise provided in the Act is just precluded. So it seems to provide that the APA's catch-all doesn't even apply. If it's there, it's there. If it's not, it's not. And the APA is just sort of irrelevant when it comes to deciding whether or not there's a cause of action that's left over. The court looks at this in a couple of ways. It says, we've got this presumption in favor of judicial review, which basically means that we narrowly read statutes in a way to ensure that there's going to be judicial review provided.